at the end. Gives them more time to go through those minutes of the 12th of April.
Chairman, we can do that at the end, though.
All right, Member Gill, thanks. Okay, so we'll do that at the end. So basically, I think we have CTD Murray here from the ministry, and I know the LRD is here as well. CTD Murray, you wanted us to remind me of the first item, the review of the specific section, section 4 and cyber stalking. It was for the membership to make a decision based on the recommendation from the team.
Morning, Chairman. Morning, members of the committee, and morning, colleagues. Yes, Minister, my understanding is that the committee did not signal its consideration or recommendation in respect of Section 4. Members may recall that the Financial Services Commission made a recommendation to include the words "or causes to be accessed" in Section 4, subsection 1. And we had indicated with respect to that recommendation that Section 12 of the Act already treats the matter of inciting and conspiring with another person to commit any offense under the Act. Consequently, it was our view that there was no need to amend Section to include words "or causes to be accessed." We were asked by the committee to revert to the FSC to determine what their intent was. And as indicated in the report in red, the FSC responded by email to advise that the intention of the proposed revision was to ensure that the provision captures a person who doesn't directly access, but instead facilitates the access by a third party. So we continue, it seems to support what our assumption was, that the intention is to capture someone who was directly involved in accessing the computer, but would have facilitated the act. And we remain of the view, Chairman and committee members, that Section 12 of the Act would treat with that because it speaks to a person who intentionally incites, attempts, aids, or abets the commission of any of the offenses in the Cybercrimes Act. So that's, Minister, I will pause here on Section 4 before reverting, and committee can indicate what their position now would be on that.
Sure. Members, any input on that? Member Golden Campbell?
Sure, I don't have any additional comment.
Chairman, for me, it was just a question of, reminding myself as to what the comments were. And now that CTD Murray would have advised and reminded us that it was already dealt with in Section 12. I have no difficulty in accepting the position.
Thank you, Member Gill. And with that said, if there's nobody else, then we will accept and proceed. All right, so CTD, are you clear on that now?
Yes, Minister. So I take both responses to mean that the committee is agreed that there is no amendment that is required to Section 4.
Correct.
As proposed by the FSC.
That's correct.
Right.
That's correct.
On the matter of the stalking, the committee members will recall that there was a recommendation made to introduce an offense of cyber stalking the Legal Reform Department would have done the research in relation to this and would have advised the committee that they had prepared a position paper in respect of this. And because there are several pieces of legislation that would be equally impacted as it relates to this particular proposed offense, the Offences Against a Person Act, the Sexual Offences Act, the Domestic Violence Act, as well as the Child Care and Protection Act. They would have advised the committee that they had prepared a paper and submitted same to the Ministry of Justice as to how to treat with the issue of cyber stalking. And in light of that, the issue of stalking would either be dealt with in those legislation, bearing in mind that what would happen now is that irrespective of whether the stalking happens in the physical or in the virtual, same would be captured or dealt with, or an offense would be created in respect of it. The LRD would have also indicated that in light of the discussions that committee was having around the Section 9 and the proposed amendments to that, then elements of stalking in the form of harassment would be addressed in that Section 9. So that conversation, Minister, committee members, still continues in that I believe there is some reporting back from the Legal Reform Department on the Section 9 issue. And once the committee, I believe, settles its mind completely on the Section 9, or what the amended Section 9 will look like or likely to look like, then this would in part deal with the cyber stalking issues, bearing in mind also that recommendations have been made by the Legal Reform Department to the Ministry of Justice in respect of in respect of stalking as it relates as an offense generally. And would be considered in the context of the Offences Against a Persons Act and the Domestic Violence, etc.
All right, thank you very much. So with that said, we can actually turn over to the LRD. Who is leading from LRD?
Miss Erica Simon, Minister.
Okay, Miss Simon, are you on?
The research relating to the trend where persons have been sending certain kinds of photos concerning, say, accident scenes, for example, those kinds of graphic photos via social media. And we committed to undertake research to see what kind of provision has been made in that regard. And having examined all of the various cybercrimes legislation out there, we were unable to find a provision that dealt with those kinds of that kind of data specifically. What we found was that provision was made for grossly offensive content in 3 jurisdictions, in Kenya, in India, and in the UK. So the offense in Kenya and India essentially is where you send a message or data that is grossly offensive, indecent, obscene, or menacing in nature. You would be found to have committed an offense. The issue with those provisions is that they have been challenged in those jurisdictions and have been found to be in breach of the Constitution. In Kenya, the provision was found to be vague, broad, and uncertain, so that individuals would not know whether or not their communication falls within the provision, and therefore that section offended against the rule requiring certainty in legislation that creates criminal offenses. In India, they found that the terms were, that term, grossly offensive, was open-ended, undefined, nebulous, and imprecise. And they concluded that it was unconstitutionally vague, arbitrarily, excessively, and that it arbitrarily, excessively, and disproportionately invaded the right of free speech and upset the balance between the right of free speech and the reasonable restrictions that could be imposed on such a right. The provision in the UK is a little different. There are two sections, one in the Malicious Communications Act, which makes it, amongst other things, an offense to send a message which is indecent or grossly offensive in nature, and where the person has as his purpose causing distress or anxiety to the recipient or any other person whom he intends that its contents or nature should be communicated. The other offense is found in their Communications Act, which makes it an offense for a person to send via public electronic communications network a message that is grossly offensive or of an indecent, obscene, or menacing character, or causes any such message or matter to be sent. We were not able to find any judgments pronouncing on whether or not such a provision was broad or not, as is done as we had found for India and Kenya, but we noted that the Crown Prosecution Service had issued guidelines as to what would be, as to when prosecutions could be initiated for something that would be considered grossly offensive. And to us, the fact that they had to issue guidelines signifies that the term is vague, it's broad, so they needed to issue those guidelines. And we also note that what the guidelines consider as grossly offensive is fairly narrow. So prosecutions would only be commenced if the communication amounts to something that is more than offensive, shocking, or disturbing, or satirical, iconoclastic, or a rude comment, or the expression of an unpopular, unfashionable opinion about serious or trivial matters, or banter or humor, or even if it is distasteful or to some or painful, or if it's an uninhibited or ill-thought contribution to a casual conversation. So whatever is sent would have to be more than any of those things.
Chair, I'm sorry. Could I just ask LRD just to repeat the list of those things, please?
Okay, sure. So the guidelines that were issued said that a communication would be considered, that prosecution, would only be initiated if the communication amounted to something that was more than offensive, shocking, or disturbing, satirical, iconoclastic, or rude comment, the expression of unpopular or unfashionable opinion about serious or trivial matters, or banter or humor, even if distasteful to some or painful to those subjected to it, or an uninhibited and ill-thought-out contribution to a casual conversation where participants expect a certain amount of repartee or give and take. So the communication would have to surpass any of those categories for them to consider initiating prosecutions, which to us supported the view that the term is too broad, it's too vague. And so we would therefore, based on the other two jurisdictions and based on that prosecution guideline, we would advise against the use of the term, which is the only thing we found used that we think would capture the kind of images in question. But if the committee is still minded to use the term, then we think that the term should be narrowed, either by defining the term to say that it covers data, grossly offensive covers data portraying violent events resulting in death, serious injury, or the maiming of a person, or that kind of phraseology could be used instead of the phrase grossly offensive. Another thing we'd want to note is that apart from the issue,
Ms. Simon, just repeat that last statement you made now.
Okay, so
in terms of defining, narrowing it down.
Okay, so it could be narrowed, we think, to data that portrays violent events resulting in death, serious injury, or the maiming of a person.
Thanks.
Okay.
Chairman, could I come in here as the person who asked the question? My view on this matter is that I believe the current provision in Section 9 actually covers this. And I would like, I know we have LRD, but we have AG and we have others. I believe the current section covers it. And I want to just read 9(1) as it is. A person commits on use of computer for malicious communication. A person commits an offense if that person uses a computer to send to another person any data, whether in the form of a message or otherwise, that is obscene, constitutes a threat, or is menacing in nature. I believe obscene would qualify here. But I want to go further to go back to some guidelines that our DPP had established back in, I think it may have been 2017. And she said, I'm going to read, she identified 3 ingredients that must be proved by material presented to an investigator before a prosecution can be initiated. 1, that a person uses a computer to send, and she had said at the time, send is not defined under the current legislation, and as such, arguably, it may include the publishing of material by a person to a social media site. That's 1. Secondly, that the data sent is obscene or constitutes a threat or is menacing in nature. These terms are not defined by legislation. Material that is obscene is of a sexual nature or offends against society's morality and tends to deprave or corrupt minds open to immoral influences and into whose hands these publications would fall. Threatening material is material that intimates that harm, danger, punishment will befall a person and may be similar to a menace. Material that is menacing in nature tends to threaten with harm or danger. And then the third one, that the material which is either obscene or threat or menacing in nature, or all 3, or a combination of the 3, was sent with the intention, and emphasis with the intention, to harass any person or cause harm or the apprehension of harm to any person or property. So when I look at the current legislation and I look at the guidelines that the DPP had instituted based on how controversial this clause is, I actually believe the current legislation covers it. That's my uninformed, non-lawyer view. But I would question whether we actually need new legislation. The only part that item 3 in the guidelines that the DPP had with the intention, right? Yeah. And some of the cases that we have seen probably would not meet that threshold of with the intention to harass. And so it may not rise to being something that you could successfully prosecute. But as I said, it's just my view. I'm not sure that we need a new provision here based on the current legislation.
Following on what the member just said, we agree that obscene could cover some of those images, which was one of the reasons why we did not agree with the proposal of the DPP's office to remove it, because it is broad enough to cover more than sexual images. It could cover these kinds of gory images as well. But as you also indicated, there is the fact that you would have to prove the intent. And that is a concern that we had with the other jurisdictions where the provisions were struck down, was that there was no requirement of for you to have that intent, which we think would also make the provision a bit too wide.
So your conclusion then is that based on what you have seen, you don't think an insertion of this would be constitutional based on what you have seen. That's pretty much what you're saying.
Not unless we try to narrow the scope by defining the term.
Okay.
I don't know if the AG's department wants to weigh in on this.
Mr. Chairman, even before the AG department weighs in on it, that which was just read by Member Robinson, can it be put up on the screen, please, just so I can have another read through of it? Please.
Let me see if they'll allow me to share screen. Share screen. Where is it? You can see it now?
It started, yeah.
All right, so this was done by the DPP's office May 15, 2017. So I'm just putting the section related to, and I can email it, but I think, Joaquin would have it and others would have it. But this is the section.
Just to interject, it was sent with the DPP submission. So if you're able to locate the original DPP submission, you should find it.
May I ask if it can just be resent right now during this meeting? Because I realize it might be problematic, some people having this on the screen, and it's just for my use. If somebody could just email it right now back to me, that would help, because I want to comment, but I want to be sure of what I heard. Please.
I've been waiting on that. I was asking whether the AG department wanted to weigh in on this discussion. All right, not hearing from them. I'm not sure if they're on or. All right, is somebody emailing to member Rodriguez Campbell? Ms. Brandon? CTD Murray?
Yes, Chairman, just give me a few. I will send it to members.
Thank you.
Anybody else wanted to weigh in on this, or we just wait on member Rodriguez Campbell?
I thought the AG's office was going to respond to based on your ask.
I asked them, but I didn't hear them at all. I'm not sure if they're on or away from their
In the meantime, what we understand based on the last discussion, what we are seeking to achieve. Based on the research done, it really means that we have to narrow down the definition somewhat. Because one of the things that we don't want to do is to leave it open-ended and vague. And that would make the course of prosecution more challenging. If we don't narrow it down, what I'm seeing depicting in a lot of the jurisdictions would make the bar too high for us to be able to prosecute. And it's just a question now of us narrowing down the definition. Now, when I look at material that is menacing in nature, that tends to threaten with harm or danger, and 3, and that the material which is either obscene or a threat of menacing in nature, or all 3, a combination of the 3 was sent with the intention to harass any person or cause harm of the apprehension of harm. The difficulty that I have with that is that there might be no intention to harass, but it's just a question of transmitting the information and the harm that it would have caused. And so I believe, Chair, we have to find a way to really narrow down the scope in what we are trying to achieve. And so you
share an
don't,
example
you really don't want to make it so open-ended and so wide so that it would give challenges to a prosecutor in bringing a case against the perpetrators.
I want to share an example, totally different jurisdiction, different matter. I don't know if all of us remember the case of Kobe Bryant's death in the helicopter crash, and his wife sued I don't remember if it's the LA or the whichever county, the first responders, because they had actually, when they got to the scene, they took pictures of the crash scene, and those pictures were shared. And she actually was successful and won, I think, close to $29 million in a lawsuit based on that. It's a totally different jurisdiction and different sets of laws, but I was just reminded of that when I thought about scenarios like this. I don't know if the people in that scenario took the pictures with an intent to harass, but there were clearly breaches of the laws there, and the relevant agency settled with her in that case.
Member Robinson, through you, Chair, that case that you're referring to sounds like it would have been a civil suit, was it?
I think it may have been a civil suit. Let me just do a quick Google.
It was a civil suit. It definitely
it would have been a civil suit.
It was a civil suit, for sure.
I must admit, sir, that I think I was late to the meeting when this was discussed before, but this matter of criminalizing this is a little concerning to me. I'm trying to understand our policy intent behind it. I don't know if that could be reiterated.
Well, I raised the question, Shireen, and I asked the question whether, the sharing of images from crash scenes, and I would expand it to include violent crimes where people are shot and killed, whether it was covered under the current legislation. So I asked that question because I've seen a trend where I believe that trend is something which is disturbing and needs to be addressed. So I asked the question. LRD at the time said, no, it was not covered by our existing legislation. And so we asked whether to look and see whether from other jurisdictions there were provisions that could be incorporated. I raise it because from my definition, from my reading of the thing, I believe it may be covered. The one element of the guideline from the DPP's office is with the intent, and many of the things that are shared are not shared with an intent to harass, although they end up creating that and having that effect. So that is the context in which this came up as a discussion item. And other members had concerns about this as a trend and felt it was something that we should look at.
Sure, I had supported the concern too, because a number of persons continue to raise this matter, and I know of a family who would have, being the recipient of such circulation, and it would have caused grievous harm, psychological harm in that, and it would have raised concerns. Now, if we take note of the traditional media in reporting on these instances, warnings would have been provided, the actual images would have been either blurred or blocked out. But social media has become another means of transmitting information, and there is no guard against this type of, transmitting of information of such graphic nature. And the real intent is for us to find a way to kind of cauterize it Maybe we are the only ones who are transmitting this type of information in such graphic forms. And so other jurisdictions may not have found it possible as yet to kind of cauterize it. It's something that we have to deal with, Chair. And whether we do it today, whether we do it under this particular legislation, I'm suggesting that we ought to find a way to treat with it.
Mr. Chairman, I have to beg the question, because something is offensive to my generation and the generation before mine, does not make it a criminal act. And we have to be careful that what we're seeking to do is solving a problem that is offensive to a particular generation rather than a problem to the wider society. Sending photos, it's the same matter of my daughter prefers to send a text message than calling. My generation and the generation before mine, we prefer to call. We find these photos offensive, but I don't think there is a member on this meeting right now below the age of 30. Are they as offended as we are? Is it that we legislate and make something criminal because it offends us? We have to think about those issues. I don't believe this should be a matter that is criminalized at all. I think it's a generational matter, and we have to find another way to deal with it rather than criminalizing it.
Chairman?
Go ahead.
Thank you. Sorry, my apologies for being late. I had another situation I had to be dealing with. I'm listening to the discussion, and I can't help but recognize and have to put the input of it goes back to the mental health damage that is being contemplated. I'll just say one or two things, and in so hopefully contribute to the discussion. The intent. I'm not a fan with mens rea in terms of the actual active intent to harm, but I think that we need to make provisions for perhaps in a separate clause or a separate provision for the active intent to be malicious in the transmission of whatever material. So you have the person who will know actively that this may offend someone, and because of that person's particular predisposition, it might not affect someone else. Let me give an example. A child who is bullied, a child who is autistic and has a particular predisposition for certain peculiarities specific to that condition. Another individual knowing that they are sensitive to that. That material is not offensive to the public. It's not offensive to the other person, but they know that this will trigger this individual. That is intent. That is an actual intent to maliciously hurt that individual. The other consideration for me is around the fact that the level of mental health impact, it goes back to the discussion between psychological and mental. If someone receives, which I think was one of the basis for that situation that was mentioned with the Kobe Bryant crash, is that persons can be traumatized by receiving information that is so damaging that it not just impairs them in a capacity to cope with the trauma, but it could trigger post-traumatic stress disorder. It could trigger psychosis. So you can even trigger even more severe manifestations in the individual who receives it. So I think it is really very, very critical for us. I don't think, I'm very appreciative of Member Robinson bringing it to the fore, but I don't think we have deciphered the subtle differences in the level of damage and the act of transmitting whatever information. And I think that we need to really make note of it, because with what is happening, especially amongst our younger population, who we have to protect against, a lot of, history speaks a lot, and sometimes what we think we automatically know as adults, they don't know, and we have to provide guidance for them as to what is harmful and what is not. So I think that we need to, I personally think that we need to decipher between, I don't know if it was probably along the lines of what member Golden Campbell was saying, whether criminal versus civil. If the intent is there, perhaps it's a criminal matter. If it is not, maybe it's just a civil matter, and perhaps we can delineate it that way. Thank you.
Thank you very much, Member Longmore. So,
Here, before you move on, can I just throw some things out to the committee for consideration on this point? Because what I'm grappling with, every time we create an offense in a piece of legislation, we simultaneously put on law enforcement a duty to police in relation to that offense. And my concern is that I'm trying to grapple with how law enforcement would police this, because we're particularly talking about social media and the ability to transmit images through social media. Now, my little observation on, let's say, Twitter, for example, a lot of the names and handles on Twitter don't come with the proper name of the person. People tweet and their tweets are retweeted. How do you police that? How many rungs down the transmitting of images like this will the law be applied? It seems to me we're creating a raft of processes for law enforcement to engage. And I find it a little bit problematic, because it would seem to me that the resources to follow all the transmissions of these messages would tie them up. This is not to negate the harm that may be caused to someone from the transmission of these messages or these images. But I just feel like maybe this is one of those that ought to lie in the realm of the civil remedies as opposed to the criminal remedies. And then, of course, there's a discussion of intent and no intent. So I'm just trying to work out, when you create this, how you police it.
Well, all right, what I would say, as again, having raised the issue and not being convinced that the provisions there can cover it. I think the provisions can cover it once you can prove intent. Now, I can say there are examples where I think you can find intent. And I do agree with Natalie about it being necessarily a generational thing, right? But you have scenarios where there's a victim of violent crime. That person's image is taken, reproduced. It is sent deliberately because somebody wants to send a message that we did this to person X. And so that, I'm warning you basically by sending this image that, I can do this to person Y. That to me may fall in the realm of the guidelines that the DPP sent. That might be different from a crash scene that somebody passes, takes a picture and sends in a WhatsApp group, all right? So there are differences. Now, as I said, I'm not convinced that the provisions there are insufficient. They probably are. They can, Shireen, in cases where people use pseudonyms as many people do on social media, it's not very hard to get behind the pseudonyms and find out who the real individuals are. But the important point for me here is the issue of intent. And I think that's why the DPP had published those guidelines. I'm not pushing necessarily for stuff that will become unconstitutional or will be challengeable. And maybe the remedies around the where you don't have intent, there may be a different solution that we may have to find to that particular one, where it is just done as a, a thing to do. You just send images around. But they do actually create that damage to people, particularly family members. So to summarize, Chairman, is my view is I think the provisions cover it under Section 9 with the guidelines that are there. The issue, as the third item, as we say, is intent. And if intent is there, then you can prosecute. If intent isn't there, it doesn't rise to a prosecutable offense, but it's probably something that you may have to address through a non-legislative means, public education or something else.
Thank you, Member Robinson. My two sentences on this is very simple. The police have a protocol that when they go on a scene where somebody has been killed, that they don't release the name of the person until such time as the family, next of kin, has been notified. As you said before, the mainstream media has protocols in place in relation to the images that they send across and the warnings that are given. What we're finding is social media does not have these protocols. And the problem that I have is that despite the fact that there are protocols in mainstream media and with the police force, etc., it's very difficult for a family member or a loved one to be notified or to become aware of the demise of one of their loved ones through picking up their phone and seeing a picture either of death or severe injury, where obviously the whole issue that Member Longmore mentioned comes in terms of the effect psychologically, etc., etc. I'm not here as chair, and I'm sure the membership would agree with a big stick to criminalize it, but we definitely have to find a way to deter that type of behavior, because the fact of the matter is that it is unacceptable to me, and I would hate to be put in that position where I found out about the injury or death of a loved one by virtue of it popping up on my phone without any previous knowledge that there has been an incident or whatever. And therefore, I mean, I hear what Member Robinson said, and the truth of the matter is that if we can use that, and obviously try and deter, as you said, we don't want to do anything that will be challenged and get into a legal gas. But I feel strongly, very strongly, that this committee is doing the right thing by at least exploring it and looking at it to see what can be done. I'm not quite sure why the social media entities would not be also held responsible for that type of images. But I guess, I mean, as we know, where social media has taken us, I mean, it's a difficult one. But I'm in full support for Member Robinson to bring it up, and of course to have this discourse, and of course agree and agree to disagree. But if it is that the section that you mentioned is there, maybe that will be the way to remedy it, and to at least have people have the option to pursue if they feel that there's intent. So I throw that out and wait on the feedback.
Minister, might I just recognize the importance of what you mentioned regarding the operators of the social media space. I know that there have been cases filed against Facebook, Instagram, where persons who are in the process of doing criminal activities, including and also self-harming behavior like suicide, etc., have actually been taken to court for their lack of control on such circumstances. And I think that while we contemplate where we're going with this piece of legislation, I think that we need to make it clear that there is a certain standard, and whether it is through a significant public education program, I think that when we finish with all of this, that is going to be very, very critical. But we must provide provisions for what is acceptable and what is healthy for the country in the virtual space. Thank you, Chair.
Member Rodriguez Campbell, any comment from you on that?
Mr. Chairman, I still don't, I'm not sure where we have left it because I've heard different things. I think I lean towards what you're saying, that it shouldn't, and I hope I heard you correctly. We shouldn't criminalize, but we need to find a solution. Because it's easy to criminalize, but it doesn't solve the problem. Because as Member Golding Campbell said, when you criminalize something, the police has to have the capacity to police it. Criminalizing this, there's no way for the police to really, or a constabulary force to police this action. So I'm still not sure criminalizing is the right way to go. We need to put our heads together and find another solution.
Member Gill?
The fact that we are deliberating on this matter, it suggests that there's cause for concern. I'm glad we are having the discussions. We would have expressed varying views. I am leaning towards what you would have suggested, that we need to find a handle on this. And as I have suggested before, we haven't found it yet. I would also lean towards what Senator Golding Campbell would have expressed in terms of the possibility of it coming across as a civil suit. I've said before that, we can't make the thing so open-ended and wide, to which would be found challenging to prosecutions. But we are discussing it, Chair, and I believe the discussion can continue at some other time. Thank you, Chair.
Member Robinson, as the person that raised it originally, may I hear your final position?
My final position is, when I asked the question, I asked because I wasn't sure whether what was there was sufficient. Looking at the provision, looking at the guidelines from the DPP, I believe those provisions may apply in cases where you can prove intent. In other cases where you don't have intent, you wouldn't have a successful prosecution, even though the behavior is obviously behavior that we don't consider to be the best interest of society. In a scenario like that, as I said, I think we may have to look at alternative ways of trying to address that behavior, which doesn't rise to being something that can be criminally prosecuted, and it may be something through public education or other means to dissuade people from engaging in this practice. But I think the provisions that are under Section 9 with the guidelines are fairly specific in terms of what you are able to prosecute. And where intent can be proved, you may have to pursue a civil remedy. But I think it is something that, as lawmakers, we should put our minds to in a public education campaign to dissuade persons from this practice, which is clearly harmful to a lot of people.
LRD, Ms. Simon, let me just ask a quick question. In terms of what Member Robinson is speaking about and the section he's speaking to, would that give if a report is made by an individual, would that give the police or the DPP the option to pursue both angles, meaning that they would be able to decipher whether it is intent or not, and whether or not it is to be pursued criminally or to be pursued through civil?
You mean the
Through the
existing
civil
Section
route.
9?
Yes.
In Section 9?
Let me tell you why I asked that question. I have myself personally forwarded to the police at least 25 to 30 posts that have been made that I find offensive, particular to specific to me. And the standard answer from the police when I send it to them is that there's nothing in the law for them. The only avenue that I have is to pursue a civil suit. As you know, the average person who may be affected by this is not going to be in a position to pursue the civil route because of obviously the expense and the time. So the truth of the matter is that that would leave it open to just a very few persons who would have the wherewithal to pursue it because they feel strong on the matter. So that's why I'm asking, because the police tell you standard once you send it to them, no matter how offensive it is, no matter the clear intent, they say that the only option based on how the law is structured now is through a civil action.
Well, I think that would be because what our provision says is not offensive but obscene. So it would have to be something that could be considered as obscene, because I don't think, based on what you're describing, that threat or menacing, it would qualify as a threat or a menace. So it would have to fall under obscene, and if it doesn't, then yes, you would be without a remedy criminally under Section 9.
But basically, it would give the police the ability to make a decision to go one way or the other. Whereas right now they only advise you to go one way. That's what I'm trying to get at.
Well, they should assess, I think, based on how the section is worded, whether or not it is obscene before telling you that you have to go civilly. So they would have to make a determination that it's not obscene.
The question that I'm asking is that when we finish this review and we sign off on it, and there is a new Cybercrimes Act in place, will what we just discussed and the section that we're speaking to, will that give them more flexibility in terms of the way that they want to go based on the particular complaint? Meaning civil or criminal?
Based on my understanding of what the committee was thinking of the provision, this section would not change in terms of its wording. So I don't think that anything would change in terms of how they have been proceeding, except maybe they need more education as to what the section covers as well. Maybe it's that they don't understand fully.
I mean, at this point, obviously, that would be the best case scenario with the review, so that, I mean, persons could get the recourse depending on the particular situation. So if it is that you're saying that
I definitely think that's education. Public education definitely is going to be important, not only of the public, but of the police as well. Clearly, based on what you have said of your experience, that they need more education in terms of what the provisions enable them to do.
And in your mind, based on what we have, the amendments that we have made, and what will go forward now as a new revised act, you're saying that if they look through it and review it properly, they will see where they have options, is what you're saying, in essence, eh?
They should, but I think education would also be important, because maybe it's that they're reading it and not understanding fully what they're able to do.
Mr. Chairman, may I ask a question to the LRD on this? Did I hear you right when you said that in response to what the chairman has said about social media slander towards him, and the police is saying there is no recourse based on the given law, were you saying that actually there are laws that could remedy that situation, but it's just that they didn't read it, they don't know of it?
No, that's not exactly what I was saying. What I was saying is that they, based on what I understood the chair to say, was that when he made certain reports, they said it didn't fall under the law. And I'm looking specifically at Section 9 and the requirement that the data be obscene, a threat, or a menace, and sent with the intent to harass. And if it would have to fall under one of those heads, being obscene, a threat, or a menace, for it to be able, for them to be able to prosecute it under that section. And based on the classification of the posts or the messages or the data as being grossly offensive, I was just thinking that the data in question would have had to be seen as obscene to fall under the section. And I was just speculating as to whether or not it is that they did not understand, or they didn't understand that obscene, what it means, what it covers, and that maybe it's that they hadn't properly considered whether or not what was shown to them could be, whether or not it is obscene. So that's what I was wondering, whether or not they had properly considered that issue, and whether or not it's therefore a question as to whether or not they need more education as to what the section covers, so that they would make better assessments going forward.
So I fully support you on the need for greater education, especially by our security forces. And it brings me back to the discussion we had in the last meeting, Mr. Chairman, about the word obscene. I think we had agreed that it would be defined. Is that what we agreed? Can I be reminded, please?
I think there was a concern that it would be a little difficult to define it.
What about, because that was the reason I asked when Member Robinson read the document that he did, I asked it to be sent, and I looked back at it, and the DPP has defined obscene. And the way she has defined it, if you can take a look at it, it's so open that it would actually take in. But do you think there will be a problem not defining it?
Not necessarily, I don't think. It would be, by not defining it, they would still have to make an assessment on a case-by-case basis based on the circumstances. Look at the particular data in question, the person that it concerns, the person who sent it, and make an assessment. So even without a definition, that kind of analysis would have to be done. It's just that a definition might make that assessment easier, but my understanding from the last meeting was that it was thought that it would be a little difficult to pinpoint what obscene is.
Right, and I still support that decision. I just wanted to be sure my memory was correct on the matter. Thank you so much.
Okay.
I think in many other cases where issues go to the police for determination, it's important that there is consultation with the DPP's department about the validity or whether it is a case that can be pursued. And I think, Chairman, that I don't know the specifics of the matters you have raised, but it may be that there isn't enough consultation with the DP to see whether those matters can be pursued, because I believe based on Section 9 and based on the DPP's guidelines, some of these matters can be pursued, but there has to be a kind of proper case review by both police and DPP. From my recollection, and I don't think we have anybody from DPP, we have only had about, I know there's certainly one very high profile case that I'm aware of that was successfully prosecuted under this. There may be others, but I wouldn't say that we have a lot of experience in our jurisdiction in prosecuting people under Section 9.
So what I'm hearing, member, is that we will leave Section 9 and obviously try and have some kind of way forward in terms of public education, and of course some further discussions with the police and the DPP in relation to that particular section and how it can be used to deal with some of these cases that are reported currently that are not getting any traction outside of the civil route.
I say CTD more with her hand up, Chairman.
Right, CTD.
Thank you, Chair. Chair, based on the discussion that the committee has been having just now about this matter, I just want to share two things. One, that the committee will recall that it has encouraged the ministry post the process of amending the legislation to engage public education and awareness campaign around the cybercrimes. And that is something sure that the ministry commits to doing once the process is complete. The other thing I would want to mention is that in the context of the Data Protection Act, there are issues that arise with the processing, which includes dissemination and communication or transmitting data that is of a personal nature. And that is an area as well that the ministry, along with the Office of the Information Commissioner, which both of whom will shortly embark on a public education campaign around the Data Protection Act, can treat with this particular matter, because the extent to which the data that is being shared are pictures and images of individuals that are recognizable, it really runs contrary to the legislation, that those individuals would be considered as having processed personal data of someone else without the person's consent. And so we think we have two limbs under which we can treat with this particular issue. And certainly in the data protection, public education awareness campaign, which will start as a ministry along with the Office of the Information Commissioner shortly, this is something that we will highlight how it is that persons are using personal data and sharing that data without the consent of the individual. So I just felt, Minister, that what's important to share with the committee.
Thanks very much for that, CTV. Any other member? So can we take it that Member Robinson's suggestion in relation to Section 9 will be the avenue that persons can pursue for the law enforcement and DPP to obviously make the final decision in relation to whether or not there's intent and what route a person can use to remedy the situation in terms of whether civil or possible criminal if so determined by law enforcement. All right. All right, LRD, anything else you want to present?
No, that was it, Chair. That was it from us.
All right, CTD Murray, LRD has completed in relation to that particular issue that we have had extensive discussion on. And we already dealt with the other matter. So guide us on the next steps now in terms of where we go in terms of concluding the report.
Apologies, Chairman. Chair, I would defer to Ms. Brandon on this particular matter.
Ms. Brandon?
Yes, Chair. So based on the discussion that was had today, the report will be updated based on the committee's recommendation and sent to the members for their signature and tabling in the House.
And what's the time frame for that?
Well, Chairman, it depends on when the members would wish for the report to be tabled.
And in terms of the report being finalized for signature, what was the time frame for that?
In terms of when the report can be ready for signature being updated with the recommendations that were made at today's meeting?
Sure.
It can be ready by next week or this week, the end of this week.
All right, members. Can you say if you're satisfied with that we can actually move to this step in terms of the final report for review and signature?
Yes, Mr. Chairman.
What is proposed?
Yes, Chair.
All right. Thank you for that.
So, Chairman, is it the wish of the committee for the report to be tabled next week?
Well, it has to go to them for signature first, right?
Yes, Chairman.
So once we get all the signatures and everybody is satisfied with the final report, then obviously once the signatures are completed, then of course we can take.
So you'll send it to us by the end of this week, right?
Yes, Member Robinson.
Okay, cool. Yeah, I'm good with that. If once we have it, we can review it and then it comes for signature next week.
Excellent. All right. So can we go back to the reading and confirmation of the minutes of the meeting held on April 12th? Can I get a confirmation?
So move, Mr. Chairman.
I second it, Chair.
All right, moved by member. You got those confirmations, Ms. Brandon?
I did, Chairman.
All right. Any matters arising from those minutes? I think I would have captured in my opening remarks in terms of what was coming out of that. I don't know if there's any other matters arising that anybody wants to raise in terms of the minutes of the 12th of April. If not, we can accept the confirmation of the minutes. All right. So in closing, members, as chairman, I want to thank all the members for their diligence in terms of the meetings that we have had over the period that we have had them. And of course, more importantly, the interactions and the suggestions and sometimes the long discussions on particular items. We know how far-reaching this is. We know how important it is, especially now in terms of the way of life that we live in terms of the whole social media, etc. And of course, not to mention the MSET team and all of the supporting entities, specifically the LRD and of course AG, been very helpful, and all else who has participated. We look forward to the review and the signatures and the tabling. And then, of course, hopefully we can have the review of the Cybercrimes Act and the amendments put into effect in the shortest possible time. So again, I want to thank all the members for their participation. And of course, everybody has worked together in the best interest of what is good for the country and the people of Jamaica. So again, thank you very much. And we can all feel proud that we have been able to have this review of the Cybercrimes Act of 2015. And of course, get to the point of where we are closing off today. So again, thank you very much, everybody, and keep safe. And of course, we'll see you in the both houses of Parliament, upper and lower, when this matter is taken. Thank you very much.
Mr. Chairman, just I know you should have the final word, but I also have to say thank you to you as well for the way in which you chaired this committee over the several months. You allowed a lot of discussion and you allowed us to just work at it together. And it would be remiss of me not to say thank you. Your chairmanship added the way in which we operated in this committee and getting the work done. So thank you.
Thank you very much, very much. All right, members, see you later in Parliament. And for others, we will be in touch. Thanks so much. God bless you.
All the best to you too.
Thank you. All the best, everyone.